Thank you so much, Suhaill, for joining us and tell everyone about yourself.
Thank you, Ciara. And as Ciara mentioned, um, these partnerships and really friendships, because that's what they become, are so important for anyone in the community, right? You start, I started my own firm, but before that, I was at a law firm. And building these connections was key to me going off on my own and knowing that I had the right networks in place. And I think that's true for any attorney, whether you're a new attorney or an established attorney. These connections are going to be your key to success and your key to have the mental unload, because before you guys got here, that's what we got the opportunity to do, right? Unload on each other about the triumphs and the tribulations of being business owners. But as Ciara mentioned, I'm an employment attorney and I work with businesses in Florida, all across the state. Thankfully, it's much easier now because of Zoom, and I help them with all their employment matters. So whether it's hiring, drafting applications, contracts, agreements, policies, handbooks, to I have a subscription program where I'm retained by businesses where I act as a fractional general counsel on all their employment needs. So if they have a question as to whether or not they can hire someone with the documentation that they have, whether they can discipline someone, whether the person that they hired and is now pregnant had to have disclosed that when they hired them. I walk them through all the steps of the employment process, including termination. And then I also work with businesses when they are sued. So that's just, I work from them, I call it from A to Z, from hiring to firing. And as Ciara said, an ounce of prevention is worth more than a pound of cure. I say that all the time. And that's really what this presentation is about. So I'm just going to share with you a few slides that we have prepared, right? And I take, oh, there we go. Do you, and I think you could see that okay.
Yep, perfect.
So this is what I want you to do and not do and avoid, right? When it comes to hiring and firing. And I will tell you, I work with a number of law firms. They're actually one of the industries that I represent the most, right? And that's probably because lawyers, we tend to specialize. So if we're not doing employment law, we do other areas of the law and we don't know what we're doing, right? Um, and sometimes we like to think we do. I work with a lot of insurance agencies. There's a lot of issues with contracts, right? Do you have your employees or contractors on the right contract? And so we'll talk about some of these things. The first, oh, let me hold on, I didn't hit this right thing. I'm also not the best with technology, so bear with me. There we go. All right. So we're going to talk about hiring. 90% of the problems that you have will be resolved at the hiring stage, right? Do you see those captions on the bottom here? All right. Yeah. Well, and
Yeah.
they're in Spanish too.
And they're in Spanish too, so
Hold on. Mm, I'm not sure how to get rid of them, to be
I
honest.
don't, I'm honestly, I've never seen them.
No, me neither.
And the fact that it's translating what we're saying is
It's
wild.
fascinating, right? Well, if it doesn't bother anyone, I'll
No,
just keep
no, hey,
talking.
listen.
So I say that 90% of your problems are solved or can be prevented at the hiring stage. What does that mean? When you're hiring someone, that is the most important thing you do for your business. You want to think about what are your requirements? What are the things that you must have? What is important? What is critical? What is essential to the role? Then you think about nice to have, right? You need someone that speaks English, reads in English, but it would be nice if that person is also bilingual because you have some clients, right? In some industries, you need someone that's bilingual because they're customer facing. But that's the first step that you need. What is it that you're hiring for? Because sometimes we as business owners think, I'm overworked, I'm doing it all, I need to hire someone. And then we hire out of desperation. That's not the right way to do it because you might not be hiring for the right position. So what do you need exactly? What are your must-haves? Then when you're going to post a posting, post it on multiple channels. We've learned now that the different generations look at different places for job postings, right? There's going to be the millennials and Gen X that look at LinkedIn. There's going to be Gen Z who looks at Indeed or even Instagram, right? TikTok, right? Which I'm not really very well versed in, but they go to TikTok for jobs. So you have to make sure that you know that you're posting across diverse channels so that you have the right, you expand a broad net. Because if not, you're only going to get a certain candidate. And make sure that you have a structured process. It doesn't matter if you're a business of one looking to hire one. The process should be the same. You should have an application, you should have an interview process, and you should go through the interview, take notes, and all of that should be documented, right? Because if you start on the right foot, then when you grow from a business of 2 to a business of 50, you already have those procedures in place. And make sure that you are looking at the candidate's experience. If you're going to reject someone, make sure you let them know. Don't keep someone waiting. This is what I hear is the biggest complaint, is that someone will go on an interview, they think it went well, and then they're left in limbo and no one responds to them. It's a courtesy email. If you have ChatGPT, it'll help you draft a rejection email with a gentle tone for you if you don't know how to write that. But make sure that you reject them gracefully because it means a lot.
Also, Suhail, sorry to interrupt, but something
No?
that you taught me was don't write notes of the candidate on the resume.
Oh, 100%. So, and I think that was on my next slide, but it might be
Oh,
here.
sorry.
No, you're good. When you have a candidate come in, if it's a resume or an application that you have in front of you, right? Don't write the notes on that resume. For example, if you're looking and they put where they went to school on their resume, but they don't put the year, and then they come in and they're on Zoom and you see that they're old, don't write oof, old, right? Or this person is big, this person, don't write any comments on that resume. You want that resume to be clear, because what happens in these cases, right? So as a lawyer, I'm trained for worst case scenario. And the first thing I see in an employment case is that they request the person's personnel file. And what is in that personnel file? That first document, right? And you would be surprised at the things that I've read that hiring managers have written on a resume or application. So what is your objective? You want to find productive employees, right? So you're going to look for the top talent. You also want to screen out problems, red flags. If attendance and in-person work is critical to your business and the person tells you they have a hard time coming into work, you know that's not going to work for you, right? If the person tells you something, believe them. This is not the opportunity to give someone a chance because this is when you're screening out. Remember, I told you most problems can be avoided with careful hiring. And Ciara has probably heard this, and I see some familiar names on here. Anyone who's heard me speak has heard me say this. You hire slow, fire fast, right? Your hiring process should be slow, it should be detailed, and it should be thought out because you're identifying these red flags. You're also going to avoid a negligent hiring. And I want you to use non-discriminatory practices. That means you judge these individuals based on merit, based on the criteria that is important for your business. But if a person is pregnant, you're not going to not hire that person because you now learn that they were pregnant, because that is a discriminatory reason, right? I understand that it might cause some difficulties for your business, and there might be other reasons why you may not hire this person, but you cannot simply hire someone because you learned that they were pregnant, because that is a protected class. You can't not hire someone because of their age, sex, religion, sexual orientation, or any other protected categories. So what are the key do's and don'ts, right? These are the things that I've mentioned. You also want to think outside the box, right? And I saw this on Facebook yesterday, and someone was saying, looking to hire, we want a recent grad so we can help them grow. And usually you see someone, looking for experience. And I'm like, oh, that's a creative way to put it, right? They want a recent graduate to help them grow. That's great. That's thinking outside the box. They know that the criteria that they were looking to fill, it seemed like it was going to be difficult to find someone with that experience. So instead of limiting their search, they're going to train someone and work them up. What I don't want you to do is, I don't want you to neglect the interview process. It's really important. Um, Take a candidate for their word, right? Oh, I have no problem coming to work every day, but then you learn that they were terminated because they didn't want to commute, right? Or, I've had to interview individuals, or they tell me, I just don't like to be micromanaged. Well, I understand that no one does, but then when you call the references, they were insubordinate, right? So make sure you do your due diligence. And as Ciara said, don't write on the application, don't write on the resume. Make sure that if you have an application in place, that that application is completely filled out, because this is where they have the opportunity to tell you about them. So what are you going to ask for in the interview, since you can't ask unlawful questions or discriminatory questions? Ask about their job expectations. You want to know, what do they wish to avoid? That's going to help you tell you about what they expect at work. Uh, Asked if they've been fired or asked to resign. And this is important because a lot of times as employers, we give someone the opportunity to resign, right? So when we ask someone, have you been terminated? They can truthfully say no, and that could be true. But if you ask them, have you been asked to resign? May give you a different response. Um, how will your supervisor respond to a reference request? I saw an application once that said, do not call my past employers. I was like, well, that should have been a red flag to my client that I was now defending in a lawsuit. But here we are, right? Because that problem could have been prevented at the hiring stage, and it wasn't. It was ignored. They didn't really read the application. You don't want to ask about age. And this is something that we see a lot. You think it's discreet, but you're not asking how old are you? You're asking, when did you graduate from high school? Well, 2 and 2 is 4. The year of graduation minus 18 can give you their age, right? Roughly. Uh, Military service is protected, right? So we're not asking someone about the military service. Disability, and this is an issue that I see very often. And then my clients, coming from a good place, say, I want to know if the person can physically do the work. If they can or cannot, they should tell you, right? You need to have the description of the requirements, right? So if the position requires heavy lifting, that needs to be there, right? And you can tell them, can you safely perform these tasks? But you're not going to ask them, do you have any physical impairments that prevent you from doing this? The less you know about these protected categories during the interviewing stage, the more protected you are. Because what you don't want is then you don't hire them for a reason that's not discriminatory, right? You hire them because they're not a good fit, they don't meet the criteria, they don't meet the minimum qualifications, but then they're going to say, oh, he asked me when when do I go to church, or what church do I go to, right? And here's some more questions. And those are unlawful discriminatory questions, because they can say after that that you terminated them because you found out they went, to church X and they're rivals with church Y, and it's a religious belief. You don't want to know if the person is married or who takes care of their children, right? They will figure it out. It's not for you to figure out. Some of the problems also come because we as humans, I think, like to, make people feel good about themselves, and because it makes us feel good. So you give people a sense of security, right? You give long-term promises. So you shouldn't be telling someone you can look forward to a long career here. You don't know this person yet. You don't know if they're going to have a long career. Um, and we hear this a lot. You don't have to worry about job security. They don't fire anyone here. Well, you know, this might be the person. And now you have created this guarantee, this security That doesn't exist. And we're going to talk about the probationary period, but I hear this a lot and it's a misconception. You become a permanent employee after your probationary period. No, we're in Florida, and unless you have an agreement to the contrary, this is an at-will state. And at will means you can terminate someone for any reason, good reason, bad reason, as long as it's not an unlawful reason at any time with or without notice. So giving someone this idea that they have become a permanent employee creates this notion that they have a right to their position that they don't. So inevitably, when you, as an employer, use your management right and terminate this person without notice, without reason, or whatever it may be, they feel slighted, right? They feel like you've taken a right that they wouldn't have had. And then they go and they try to file what's called an unlawful discharge case. And Florida doesn't really have unlawful discharge, but you'd be surprised how many of those claims are filed. Um, and it's all based on the notion that they thought they were a permanent employee. Right? Because there are attorneys out there that will take cases that have no merit. We know it happens. The next biggest issue is, okay, you've decided now we're going to hire this individual or we're going to hire someone. How do we classify this person? And in South Florida, the case that I see the most is the cases of misclassification. And that is when you have someone classified as a contractor or a 1099, right? And that person should be classified as an employee. What does that mean? The Department of Labor has set forth factors that you're to consider whether or not the person is actually your employee or they would be classified as a contractor. This is something you're supposed to engage in every time you have an employee, unless you have, systematic type of employees. I will tell you the general rule is most people are employees unless they're, under a small category of contractors. Give you an example. Uh, my assistant, my paralegal, they're all employees. The person who cleans our office is a contractor, right? That's a service that is outside of the scope of services that we provide that can be hired to perform that project, right? And that's what you have to think about. Is this person performing work that goes to the nature of your business? Are you controlling their hours? How much control do you have? Are you controlling their pay? How much they make? If you are doing all of these, this person should be an employee, right? So you want to analyze the job responsibilities. And if that person is an employee, now you're going to be tracking their time because you're required to keep accurate time records. You're also going to be required to pay overtime. Okay. So what would you do? Typically, I would recommend that you use a payroll company so that you're tracking the hours correctly and they're paying, the necessary taxes. What I don't want you to do is just classify someone as an independent contractor to avoid overtime. Someone cannot agree to just be a contractor. They cannot waive. That's not a right that they can waive. It is incumbent upon an employer and a business to know the laws and know who would be a contractor and who would be an employee. And you have to think about these things, right? I also, let's say now you've determined, okay, I'm going to have this employee, but I don't want to pay overtime. So I'm going to ask him to do work off the clock. That's a huge problem. You don't go in and you don't alter their times. And you don't say, okay, I'm going to pay them for the 40 hours that they work through the payroll company, but then I'm going to pay them their overtime in cash. Because if it's in cash, we all know it wasn't paid, right? There's not going to be a record of it. So now we start with the introductory period. You see these, it's called a probationary period. Usually it's 90 days, 3 months. This is a key time frame for any employee, right? This is where you should be setting the ground for what you expect from this employee. During this time, it's going to be easier for you to have these discussions about what you expect. And it's also going to be easier for you to weed out someone who doesn't fit in. Why? Because within 90 days, no one should really have an expectation that they're going to be here for a long time. They don't have an established relationship or time that they've dedicated to the company. And it's easier to explain to someone, look, we tried this out and you were not the right fit, right? As opposed to leading someone on for a year and then saying, yeah, you're not the right fit. You're not performing the work that we need you to do. There's less of an entitlement to the position. But what I do recommend is that you use midpoint or mini evaluations throughout this time. I've always been a fan of the 30, 60, 90, right? You give an evaluation after 30 days. You let this person know this is how you're performing. If it's good, great. If they're not meeting the expectations, let's go through this one more time, right? Here's what I expect of you, and here's what you did, and here's how you can correct it. But I'm going to follow up with you. And then you set up, 2 weeks to follow up. If that person's not meeting the expectations, it's not going to work. This is the honeymoon period, right? So if they're not giving you their best during this honeymoon period, it's time to let them go. And you don't have to wait until the 90 days, right? If you're using these mini evaluations, it's going to give you the opportunity to assess the performance, give feedback, and terminate the employee if you need to. So what are the traits of an effective manager? Because really the problems come from the top. If you're not being an effective manager, your team sees that, and that affects the morale. So you want to make sure that you're confronting the problems and resolving them as they occur. I always say, do not leave a problem until the next day, period. I don't care if the problem occurs at 4:55, right? And you're supposed to leave at 5 o'clock. Make sure you document it, figure out what your game plan is, and have it ready for the next day if the person's gone. But you should be evaluating the problem as they occur and constantly, right? I know that we talk about, a lot of people do annual evaluations. That mostly they're a dinosaur kind of thing, right? They're becoming extinct, and what's becoming more popular is constant evaluations, right? And I recommend that, right? Why wait until the end of the year to tell someone how they did for a whole 12 months? Do you really think you remember what happened in January and December? So you should be constantly evaluating people, constantly evaluating their work and assessing them. And this is good and bad, right? Telling them, you did a great job. Hey, Ciara, you wrote, 10 policies this week. You exceeded your goal. Great work. Or to the contrary, Ciara, your goal for the week was 10. You only wrote 8. You fell a little short, but I saw your effort. Let's try to pick it up for the next time, right? We expect for you to hit 10. And this is going to help you identify problem employees. It's going to also identify where you need more training or support. Are you really giving people the training and support that they need? Or are you setting them up for failure? Because this is a huge concern. And it happens to all of us. We know what we want, but are we communicating to our employees what we expect? And if not, you can only blame yourself. And we see this sometimes when, we're all very busy, but if you have high turnover, right? At some point you take a look and you reflect and you say, is this the people that I'm hiring, or am I not communicating the job correctly? Am I not giving the right expectations, right? Because, and we'll talk about documentation, but the main thing about documenting employees' performance is to give that individual an opportunity to understand clearly what's expected and to perform. I mean, I don't know about you, but I don't like to fire people and start all over again, right? The cost is incredible. So it's two parts, right? An effective manager is good for employees, but it's also good for the company and it's good for you. And you want to make sure that as a manager, you are identifying what you expect and you're setting these goals. Sometimes we're busy, and it happens, but make sure you take a look back, and when there's a problem with an employee, you look at, was this an employee problem or was this a communication problem? Did I communicate correctly what we expect? And if not, that's something you can work on, right? And make sure you document everything, the good and the bad. So if you're talking to employees, even if it's just, hey, Ciara, you didn't meet those 8 You can put it in an email, right? It doesn't have to be a formal written warning, but everything should be documented. What are three management failures, right? Problem avoidance. And as humans, as people, we mostly like to avoid problems. My husband says that I like to confront all problems and face them. I'm, an anomaly, but the reality is we as humans tend to avoid problems. We don't like to be the bad guy. Um, and we kind of put things off as much as we can. And then what happens is that it explodes, right? If you're addressing it drop by drop, the bucket doesn't get full. But if you're ignoring the drops that are coming into the bucket, it's going to overflow. Then there's that poor communication. This is what I was discussing. Unclear expectations, right? We know in our minds sometimes what we want, but are we really getting that across? And then inadequate documentation. If you've told, and if I've said you've been absent 25 times in the last 6 months, that might seem like a lot, but it happens, right? And I've told you, 1 month you were absent 5 days, and next another five, and I've told you every month. Now here we are 6 months later, and I'm telling you, this is unacceptable. You're like, is it? Because it's gone 6 months have happened. No one's told me really anything except, and there's no writing about it. And that's why documentation is important. The first month you were tardy 4 times. The next month you were tardy and absent. This is going to be the consequence, right? And increase the discipline. And what is the benefit? What do we get from this? One, performance management. You're going to remove poor performance. You're also going to set clear boundaries. If you're telling this person that they can be absent 25 times in 6 months, right? That's a boundary. You have not established a boundary there. If 3 times in 6 months is clearly the only acceptable, and then anything over that is not, you need to set that boundary. Okay, now you've been absent 4 times. Here's a write-up. 5 times, you're going to be suspended. 6 times, you're fired. And that is a boundary, and that's a boundary for that employee. It also is going to be a boundary for the team. And it impacts the team morale. Because what happens when your team sees that one person is getting away with everything? Right? It makes the good employees feel like they don't want to do things, because it doesn't pay off to be good if, the bad employee is getting away with all the stuff, right? And then it's going to protect you from legal from legal claims. Consistency and applying your policies evenly and treating everyone the same leads to less claims. Why? Because what opens the door to claims is when you're not disciplining employees for the same behavior. Because we're all diverse. This is South Florida. And what we see is a woman and a man. We're going to use this example. Then the woman's going to say, I was only terminated for my tardies. I have the same amount of tardies as Bob. Bob didn't get fired. I got fired. It must be because I'm a woman. Right? Now, sometimes it's not because the person is a woman. It's potentially because, Bob was tardy 5 minutes, whereas, Sue was tardy an hour each time, impacting the business in a different way. But if you're not treating employees the same way, if there's no documentation showing that, then it leads you to the alternative, and it opens you up to liability.
Suhaill, we have a question here.
Yeah, where?
Does an employer need a clear handbook with consequences written out, or can you discipline at will?
So need, right? No, you don't. An employer does not need to have a clear handbook. And in fact, handbooks are a tricky area. I think employers should have a clear handbook. And in that handbook, you should have your policies, right? And what's important, attendance, and attendance, if it's attendance, it's a wardrobe, all of the things that you believe are conduct that should be followed by, by the employees. But I don't think you should necessarily put that if you violate it one time, you're going to be written up. And if you do it the second time, I don't think that belongs in your handbook. Because you need to have some flexibility, right? And there's certain behaviors. For example, when you have a handbook, you're going to have all of the conduct. It's called the code of conduct section usually, right? So there's no stealing, no gambling, no lying, no smoking, tardies. All of this is set forth. Then someone being late is not on the same page as someone stealing from the company. So usually what it will say in the handbook is employees who violate these policies will be subject to discipline. The company follows progressive discipline. However, there are some violations that might lead to immediate termination. So usually something like that is what I would include in a handbook so that it's broad enough to give you the ability to discipline, but not tie you to a specific discipline for a specific behavior. Does that answer the question? Because and it needs to be very clear. Your handbook, one, you need to have a good legal handbook, legally compliant handbook, and a handbook that is bad is worse than having no handbook. So if you're going to have a handbook that you pulled off LegalZoom or that you did not have an attorney review, I rather the company not have a handbook. I have reviewed handbooks lately that guaranteed employment rights, that gave employees a right to 1 year of employment, that set up a discipline policy that then required the employer to go through the progressive steps, and they couldn't fire someone when they stole because in the handbook it said that they couldn't. So if you have a handbook like this, I'd rather you not have a handbook, right? Just don't do it. But if you have a handbook, make sure that I call a handbook a roadmap. It should set forth your expectations, your policies, your conduct, and then what happens if you violate it, right? This is what we expect from you. This is what you can expect from us. So that's how you should handle a handbook. Um, but the best practices, if you have less than 5 employees, a handbook is less important. 5 or more, you definitely should have a handbook because now you're going to start running into the discrimination laws in Florida. So what are the best practices for counseling and discipline, right? We talked about doing things as they occur. And I want you to be specific and focus on the conduct, not the person, right? It is your tardiness is a problem, not you are a problem. Your misconduct is the problem, right? Always, always, always counsel in private, but with a witness. Do not ever counsel someone without a witness. And the purpose of counseling is to encourage this person to correct their behavior, right? So make sure you're encouraging, this is what you did, this is what we expect, and here's how you can fix it. And if you don't fix it, right, I want you to say, this is what's going to happen moving forward. And be very specific. If this is the third time you're writing this person up, I wanted to say, if this happens again, I'm going to fire you, period. Always make sure the employee acknowledges and give them an opportunity to comment because sometimes they just want to get it off their chest. And that opportunity to comment might prevent you from getting a lawsuit later because they had the opportunity to speak up versus you don't give them that opportunity and they're going to say that the lawsuit is that first opportunity that they had. Don't avoid facts just because they're bad. And I say that in my don't. If the person came in and cursed at you, right? And said, dropped 10 F-bombs, called you an MFer, whatever the words may be, no matter how bad you may think they are, I want you to quote them on that paper. You can put them in quotes so they don't come from you, right? But it sounds I always want you to think about this as if it's going to be presented to a jury. And if you're a juror and you hear, oh, the employee came in and used profanity versus the employee came in, she was late, I told her she was late, and she said, F you, F your mom, F your whole family, right? A jury is going to be much more impacted by those statements. And what I see is that we don't want to use those words, right? They're not maybe like words that we would use, so we don't want to put it into the writing. Put it in there. Use quotes. It's not yours, but it makes it much more effective. So if you don't have this documentation, it's going to impact the company, right? You're depriving that individual of giving you their full potential. If they don't know they have to be on time, they should know they have that. But if you haven't written them up, they don't know, right? That this is the reality. If it's not documented, it didn't happen. So if you haven't documented and you haven't told them, they don't know. You're not giving them the opportunity to work to their full potential. But it's also blocking your ability to take the necessary legal steps that you may need to take in the future, right? The first question, I mentioned that I have a general counsel subscription program. I get calls all the time, and they call Suhaill. I want to fire, Bob. I'm sorry if there's a Bob on the line. That's just an easy name. Um, I want to fire Bob, and I'm like, okay, so what did Bob do? Oh, Bob has been a terrible employee for the last year. All right, tell me about Bob. Well, he's never on time. He misses all the deadlines for work. And I'm like, all right, but he just made a claim of discrimination. And I'm like, ooh, all right. So what documentation do you have? Oh, none, but we've told him 100 times. I'm like, okay, so you have no documentation regarding his performance, right? No, but we have spoken to him, so he knows. And now he's made a claim of discrimination because he already heard through the grapevine that he was going to get fired, right? So now he's making this claim because he heard he was going to get fired. He thinks it's going to protect him. And now you're going to fire. Guess what I'm going to recommend? I'm not going to recommend termination at that point, right? Because what's going to happen is if they do fire him, there's a retaliation claim. And that's the problem. So not having if they would have called me and said, I'm going to fire Bob. And they said, you know what? I wrote him up 3 months ago. I wrote him up again 45 days ago. And I told him this was his last straw. Now it happened again. But Bob caught wind that it was going to happen again. So he made this complaint. I would say, you know what? Our decision to terminate predates this complaint. Let's do it. And there is support for that termination, right? It makes a difference, huge difference.
We have a question here.
Yeah.
Someone says, I see issues with generalities surrounding perceived poor performance. Shouldn't expectations for improvement be measurable, specific, and a timeline set?
100%. And that's exactly what, if you look here, be specific, right? Everything should be, when we're talking about documentation, it should be specific. If there's KPI, key performance indicators that you can track, that should be noted. And that's part of what I'm talking about, expectations. Expectations should be clear, right? If there's performance indicators, whether it be something that could be attributed to a numerical value or not, there should not be generalities, right? Poor performance, well, what is poor performance? And that's a great question because that's the problem that we see most often. I don't want generalities because they're not going to save the day. Because poor performance can be interpreted very broadly depending on the industry, depending on the business, depending on everything. So if you don't have it supported with specific focus on what the conduct is, what the requirements are, it's not going to be good documentation. And keep the tone very appropriate. I understand that sometimes we're upset, but it's like I mentioned, it's the conduct, not the person, right? Not you're an a-hole because you keep doing this wrong, and you'd be surprised. I've seen it. I've seen a lot of different things, and your conduct is inappropriate. Not you're a bad guy. No, you're not a bad guy. You just can't keep up with the performance, right? And this is what you were supposed to do, and this is what you did not do. So be specific, the behavior, the details, sensory. Use your senses, right? What you saw, what you heard, what you observed. Those are important. And use exact quotes. If this is the first time that you are documenting someone, right? Recap past events. Use this as an opportunity to say, we have spoken to you. Let's say this is the first time you call me and you're like, oh, well, this person's been late 5 times in the last 3 months. This is the first time I'm going to write them up. Okay, so we're going to use this as their first write up, but we're going to say, you know what, Bob, you were late on this date, this date, this date. This is the first time we have had verbal discussions with you, and this is your first written warning. Right now you have a recap. And always have the employee sign. Now, the question I get the most is, what if an employee refuses to sign? One, remember you have a witness, right? So there's two ways we go about it. You can tell the employee to write in, refuse to sign, and initial that. Okay? And employees sometimes do that. Or the witness will write, the employee refused to sign, and initial that with the witness's name, right? And what you explain to your acknowledgement should say that they reviewed the information. It's not necessarily that they're agreeing with it. They can write their comments that they disagree. It's just an acknowledgement of receipt. And make sure that you're putting it in the employee's personnel file, right? Not on your desk with a bunch of other legal pads that you're going to throw away at some point. And then let's say you gotten to the point where you've documented all the problems and now it's time to terminate. Make sure that you're reviewing the documentation that you have. You want to make sure that there's the pattern is documented if there's a pattern of behavior. If you have an HR department or person or legal team, verify their termination, because sometimes this person may have filed a workers' compensation claim, for example, and you may not know it, but someone in your HR team does, right? So before you just go off and terminate that person, talk to your HR or your legal team to make sure you're not going to open yourself up to a retaliation claim. And prepare the materials, right? You want this termination meeting to be effective and quick and to the point. So have the final check ready if you can. Have any information regarding their insurance or COBRA ready to go, and have a return property list. I see that this is a big problem and people leave and then they don't return property, they don't return laptops, and then the employer's scrambling to look for it. Have the list of what you've provided them at that termination meeting. The meeting should be a private meeting, right? Praise in public, discipline in private. So you're terminating the person. It should be a brief meeting, factual, just keep it to the facts, and they should have a witness present. Your notice of termination should be ready when you meet. That should be like your talking points already, right? And what sometimes when I prepare someone for a termination meeting, I outline the bullet points that they're going to go over, but that's based exactly, I draft the notice of term first, then I pull that, and then I make it into bullet points for them to talk about, right? Because I don't want them to veer off of why they're terminating. And when you're going to terminate someone, it's not a negotiation. The decision has been made. We're terminating your employment. Period. Stick to the facts. You're not going to argue, and then they say, no, I don't want to be fired. No, the decision has been made, right? Sometimes there's the consideration of allowing the person to resign, right? Depends on the facts. Or there's instances where it might be a good idea to give the person a severance, which is a payment in exchange for them signing an agreement where they're going to waive their rights against the company. And this happens sometimes, one, it's transition money. You give the employee 2 weeks, a month to help them get back on their feet. Or two, it was a termination that maybe the person was not a right fit, but you want to protect yourself from future claims. And make sure that you maintain respect. It's a business decision. It's not personal, right? Keep it to the facts. Be truthful. I'm, there's cases all the time, and I tell my clients, don't tell them it's not you, it's me. This isn't a breakup. You don't have to protect someone's feelings. Or the one that we get a lot is we're moving in a different direction, but the reality is that the employee was not meeting the KPIs, right? There were actual performance indicators that that employee was not meeting. But the manager felt bad, didn't want to tell this person that, so said, you know what, we've decided we're moving in a different direction. Well, when that employee is fired, they think that they did everything right. They're not aware because there's no documentation of their performance failures. So they think it must be because I'm old, right? So I'm the old guy, so that's why they're firing me. He never told me I did anything wrong. And then what happens? He files a charge of discrimination. And our response as a company is like, well, this guy was a terrible employee. And he's like, oh no, but during my termination, they just told me we're moving in a different direction. They didn't tell me I was a bad employee. And guess what? That creates an inconsistent reason. And when there's inconsistent reasons, that gives a presumption of discrimination. So I said, I've used this theme a few times, right? We like to avoid confrontation. No one wants to be the bad guy. But when you're doing this just to be a nice person, you're really hurting the company and yourself. Because moving forward, you're going to be changing the reason because now we know it wasn't discrimination. Like, we didn't even know how old you were. You look great for your age, by the way, but no, right? And now you're defending an age discrimination suit because you told this individual that you were moving in a different direction instead of just telling them, hey, you were a terrible employee. And we should have done this 3 months ago. But we skirted around your feelings, right? And that's the problem. And document everything and keep records for the termination. If it would have gone into this termination, if this individual would have had a write up saying these are, these are the numbers, this is what you're not meeting. Then another, these are the numbers, this is what you're not meeting. They walk into that termination with this sheet. We've talked to you 3 times, still not meeting these numbers. We're terminating you, buddy. Maybe he would have still sued. I mean, you never know because but now we have this record of showing this person that we told you that it was because of your performance. Maintain privacy. And moving forward, right? Everyone will know that you fired this person, but we at that point you can tell someone, we went in a different direction, right? People on the outside don't need to know why you fired someone or didn't fire. And make sure that you restrict the information to outside persons. And then moving forward, any references should be either to the manager, the owner, or HR if you have HR. So they only give whatever reason you terminated this person, they call and they ask for a reference. You give position held, dates of employment. That's it. You don't have to give anything else. So then what if you get an employee complaint? It is really important that you understand what a complaint constitutes, right? And what a protected complaint is. Because many times, we see that the word harassment and discrimination are being used a lot lately, right? It's their buzzwords. But what the employee is really complaining about is that they're just being held accountable, right? And so as a person receiving the complaint, you're like, oh, that's a BS complaint. I'm not going to do anything about it. And that's the biggest mistake, right? So know what to complain. If an employee uses a buzzword, harassment, discrimination, or anything of the sort, make sure that you understand the scope. You contact HR if you have an HR, and you take prompt action. And by prompt action, I mean you're going to investigate, right? And even if it's a BS complaint, I'm going to tell you why you investigate. Because now you're conducting the investigation, you're documenting your step, you're talking to all the witnesses, anyone involved, and then you're coming to the conclusion. Bob complained that he was being discriminated against because of his age. We reviewed, we took his statement, reviewed his concerns, spoke to everyone involved, and determined that there's no merit. It's just that Bob did not like his supervisor telling him what to do, right? And now you have it. If there is someone who is discriminating, it happens. But now you also have that documented, and you could take action against that employee and remove them from the other employees against whom he or she was discriminating, right? Because that is a defense for the employer that you took prompt remedial action and you prevented further harassment or discrimination. Document everything, conduct the interviews, and never ignore a complaint just because you think it's BS. That is the biggest problem that I see every day. Don't attempt to conduct your own investigation if you've never handled an investigation. Make sure you have HR or someone in legal involved. Don't tell the person who complains that they have absolute confidentiality, because that's not true. You need to conduct an investigation, and with absolute confidentiality, you cannot conduct an investigation. Really important. Do not tell the person who comes to complain about harassment, whether it be sexual harassment, racial harassment, or any kind of harassment, to just go talk it out with their alleged harasser. That's not the way to handle it. Um, Sometimes someone comes to you and says, hey, I just wanted to get this off my chest. That I don't want you to do anything about it. But as a manager, you have an obligation to investigate, even if they tell you they don't want you to do anything about it, because as a manager, you now know, and that is direct liability on the company, right? So you have an obligation whether or not that person wants to pursue it. And what happens is that they tell you this, but then moving forward, something happens, they get fired, and then guess what? They say, I told Sierra that I had this guy harassing me, and Sierra didn't do anything. And Sierra is going to be like, well, you said not to do anything, right? That doesn't matter. And don't tell the complaining party, you know what? That's just irrelevant, right? That's not true. That cannot be happening here. Take their claim, their complaint, investigate it, and document it. Let that investigation show that nothing is happening there. If you're facing a lawsuit, which sometimes you may, and hopefully you won't, make sure that you contact an attorney early. Don't try to negotiate with another attorney on your own. I've seen a lot of individuals get in trouble that way because they say more than they should. Make sure that you're preserving all the evidence, especially any videos, because a lot of videos override after 30 days. And make sure that you're not taking retaliation. If someone complains, even if you think it's a BS complaint, even if it is a BS complaint, don't fire them after because of this complaint. But I see that we only have about 5 minutes, so I wanted to wrap up and see if anyone had any more questions.
I actually have a question.
Yeah.
When you say bringing in a witness for the discipline part, or all of that stuff, should it be obviously? I'm assuming it should be someone in it shouldn't be someone that's equal to them position wise.
No, you should have someone in upper management,
Hmm.
as up in the management chain as you can. And if you don't have someone like that, there's like HR, like fractional HR companies that can serve as a witness to these types of matters. Because you don't want to have someone that's equal to the employee
Right.
sitting
Okay.
in, right? That's a great question, Sierra. Are there any more questions? I think if I stop sharing, I could see the question chat.
No, I actually had another question here too, but I forgot about it. It was that question about that.
And this was, an hour is obviously never enough to cover all these topics of hiring and firing, but I try to put on as many of these presentations regarding, hiring, and I'm going to probably do a series in the fall regarding, breaking it up. So we have the different sections have their own hour, because I think we could
Mhm.
talk more than an hour about each section.
Yes. So I was gonna my second question was the part about like, so it culture is a big deal now, right? In business, like, oh,
Huge.
culture, the employee culture, team culture, all of that stuff. How how does someone that's leading the team navigate, or when does the plan trump the emotions, if that makes sense, right? Like, because sometimes like it's that back and forth of like, I'm a human, but I got a business to run. I would assume that that's where most of these business owners land in this position of then needing to hire you, because the human makes the decision, not sticking to the plan or the strategy.
Plans are in place to protect you from human emotion,
Hmm.
right? I That being said, I think your plan should be based on the law.
Hmm.
And I think your plan should be based on good human emotion if that's who you are, right?
Correct.
And you should account for what you would do. Because if you have a plan and you're always overriding your plan because of your human emotion, then your plan is shit. Sorry. Your plan is garbage,
Right.
right? And no one will respect it. But if you have a plan that's already taking into account the future of these things, my turn, uh, then you know what to do, but you've already planned for it, considering your human emotions, right? Before. So you're not on the spot, you're not acting out of rage, you're not acting out of extreme emotion. Your policies and your practices should be based on your personal, you know, plan or feelings or things. It shouldn't just be black and white, but it should also be guided by the black and white laws and requirements so that you're not being too lenient. But if, vacation or PTO, if your plan is to give people as much time as possible and then you have it in writing, right? You
Right.
already have that set up. So you don't have to fall back. Have you considered? I'm actually I am planning a series on FMLA. Uh, I did one 2 years ago. There was a full day session on
Mm.
FMLA. It's actually very long. So I was talking to my associate about that last week, because that's where I received the most questions on lately is FMLA and protected leave. But we will keep you all posted. If you were here today, I will make sure Sierra tells you. But if that is something that you think would be helpful, then yeah, I think my inclination to do something like that is right.
Yeah, no, that's great. That's great. Well, thank you so much. This was so informative. I took so many notes and screenshots here. It's, it's someone here. What about Florida non-competes when terminating an employee?
So Florida right now, I don't believe that the governor has signed it yet, but Florida has a bill in place for the most generous non-compete law in the entire country. Currently in Florida, it is 2 years, a geographic scope that's, reasonable, and they're highly enforced. If this bill becomes a law, and it would become a law July 1st, supposedly, they say that the governor's going to sign it, unless I missed something in the last week. I don't believe he has. But it would extend it to 4 years. So that is important. But if you're going to terminate someone, if you have a non-compete, non-competes should only be for individuals in high levels. Those are going to be enforceable. If you have the person taking out the trash with a non-compete, you need to reconsider who has a non-compete. And then if you're terminating, one of these high-level executives with a non-compete, usually I say consider giving them a severance pay, which sometimes they call garden leave, for the time in which the individual is going to be unable to compete, right? Or less. Let's say you give them 3 months. If they have a 1 year non-compete period, that kind of gives them a 3 month severance pay, and it kind of bridges the gap. But you should really consider those things when you have a non-compete in Florida.
Awesome.
Okay? Awesome. So
Well,
thank you, everyone, and thank you, Sierra. Every
thank you,
time that
Suhaill.
I
This is
have the
great.
opportunity to talk to Sierra and we get to put something together, I feel like it's magical. So it
Yeah.
always feels good between us. So thank you
As
so much
always,
for your time.
thank you. And I will send everyone Suhail's information, where you can find her, where you can connect with her. And thanks guys for coming. We're going to do this series quarterly with different professions that all business owners need. So if you have any suggestions or what you want to hear about, what you want to learn about, let me know. Thank you all so much for coming.
Thank you.
Thank you.